Special, the Honorable Adrian N. Young, the Honorable Daniel S. Kalapin, and presiding the Honorable Matthew S. Packer. All persons have been here and brought here, their attention and shall be heard. God save the United States, the state of Michigan, and our court, please sit. Good morning. Welcome to the Michigan Court of Appeals on behalf of myself, Judge Young, and Judge Kropkin. This is panel 5 for the November 2025 case call. Really quick note, I know people just got bar admissions. I just want to note Michigan Court of Appeals can admit people. We have read your briefs and other submissions and are well acquainted with each of your cases. You do not need to rehash the facts or applicable law. Oral argument is an opportunity to highlight something beyond what is in your brief or to clarify any point that may not have been as clear as you intended. By court rule, each party is allowed a total of 30 minutes for argument if opposed, or 15 minutes if only one side is endorsed, as I believe is the case in our criminal cases this morning. If you plan to divide your argument time with another endorsed attorney, please advise us of that at the outset. If your clients are present, please inform us so we may also welcome them to the court. Because arguments are recorded and published publicly on YouTube, we caution counsel not to mention the name or location of any minors or vulnerable people. And with that, we will now call item number 1, docket number 369879, People v. Jemison. And I believe we have someone remote. Good morning, and whenever you're ready.
Good morning, Your Honor. Susan Walsh on behalf of defendant Walter Jemison. I was preparing for argument today, and a close estimate is there's about 100 pages of briefing on this case, so I think it's really been thoroughly briefed. So, and the court has already mentioned not to repeat things that are already in the briefs. But one thing that I would like to emphasize that I don't think, I know that your honors have very busy schedules, so I'm assuming that you haven't read the trial brief, but or the trial transcripts. But I know that your clerks and pre-hearing attorneys have. And some of you may know I've been doing this job for several decades. And when reading the transcripts in this case, it immediately jumped out at me that this notion of stress and anxiety from this event was just rehashed and rehashed and rehashed by the prosecutor. And I can remember just thinking, what is happening here? It was very unusual to me and something I'd never seen before in all my years. So I did want to emphasize that. And I would encourage talking with the clerks and pre-hearing attorneys that did read the transcript and getting their insights on that. I think the defense counsel did the best that he could with the situation. And there was just so many questions on it that it was probably hard for him to keep up. And other than that, the other issue that I kind of wanted to touch on.
Ms.
Yes.
Walsh, can I just interrupt you briefly before
Sure.
you move to another area? My understanding of the objections by defense counsel through all of the testimony around anxiety and that sort of thing was an objection on relevance. And it seems to me that one challenge here is that relevance is a notoriously low bar, and that there wasn't an objection to say, for example, that even if relevant, it's substantially more prejudicial than probative. And so when we look at relevance, again, if there's really any way in which the testimony will make certain facts that are material to the case more more likely than not, then, typically we allow that in subject to a 403 analysis along the way. So I don't know if you could speak to this issue, because I know that the trial judge overruled many of the objections, saying this is relevant to credibility, this is relevant to intent, and then I think they went on from there.
Yes, this is an issue that I see frequently in recent years, where defense counsel is making objections, but then the court finds that they're not the right objections. And my heart just goes out to the trial attorneys. I get to sit in my office and have peace and quiet while I do my work. I can't even imagine the strain and the stress on these trial attorneys. I have friends who are trial attorneys. I think that in this situation, it would have been similar to my reaction. Like, what is happening? What is going on here? And so he's thinking on his feet, and he's doing the best that he can under the circumstances to raise this issue and preserve it for the record. So I think that he did an admirable job. And I wouldn't want to argue that he was ineffective in that regard. But again, I do want to protect the interests of my client. And if that was ineffective assistance, I would raise that now. But I think that to make the objections that he did was enough, and that it was effective assistance, and that the questions were irrelevant. And could there have been other objections? Possibly, but I don't believe that it's necessary to make every possible objection to each question. So are there any other questions in that regard?
No, I appreciate your response. Thanks.
Thank you. Then, excuse me?
I thought one of your stronger points was had to do with the other acts evidence or improper impeachment evidence with regard to the jail phone call and the reference to taking a hit on rats. And I was just wondering, I think that then the tougher question is, how does that affect substantial justice? How does that affect the results with everything that came in with identification and all the other evidence at trial?
Well, I think it really affected the trial. And that was one of the next things that I was going to point out, is how difficult it was for my client. And with the alibi defense, it's 9 months later. And I think that if he would have had alibi witnesses who testified, then, they're lying. They can't remember what happened 9 months ago. He didn't even get a chance to talk to them till it was 9 months later. So it was a catch-22 for him. There was really, it was almost impossible for him to defend these charges. And as far as that jail call, it was very hard to understand. They were using, street lingo and whatnot. And so, the jury is left to kind of guess what was even happening in that phone conversation. And then you add that to the fact that there's no physical evidence connecting Mr. Jemison to this case. These witnesses, the two informants, there's no doubt in my mind that they could have picked somebody to take out for this in a flash at that moment. And so, it happened to be Mr. Jemison, and then nothing even happened for 9 more months. So I think that it was extremely prejudicial to him. And
well, and obviously it's the prosecutor's burden throughout the case, but in terms of the different theories of the case, what are the incentives of the two lead witnesses to, is the theory that they that they intentionally misidentified Jameson, or that they, it sounded like in closing arguments, sounded like the defense theory was that they thought it was Jameson, but really it was somebody else. And I'm just trying to figure out what's the, since they did identify him right away, what is the strongest theory for why the jury could, could have rejected that identification?
Well, that they were in an argument with him and they wanted to retaliate against him, and having him in prison would make it safer for them in their day-to-day life.
Any other questions? Any final points? Otherwise,
I just had a quick point on the addict informer instruction. I think that the prosecutor did say that one of the complainants was not using drugs at that time, and they were found in Mr. Ordaway, they were found in his system, and then argued that he ultimately became sober after this event, but I don't think that's relevant to whether or not that instruction should have been given. So other than that, unless the court has any other questions, I would rest on my pleadings.
Counsel, whether or not they use drugs at or around the time of the offense is a separate, albeit related, inquiry to whether you're addicted to substances, right? I mean, you have to
I would
have
think so.
more than just, were you high at the time of the offense, yes or no, to get the addict informant instruction. Or am I wrong about that?
Well, I suppose that, there was, I don't think ever any doubt that these were drug users during their testimony. I don't think that that was something that was trying to even be argued. But I think to get the addict informant, the purpose of that instruction is to give the jury notice that, these people could be acting in certain ways in order to keep their, drug supply flowing. And so I think that, yes, that just to have, I mean, how often do people just randomly have that kind of drug in their system on just one given day of the year or something? Those are the kind of drugs that people become addicted to. And so, but I do see that what you're saying, and I would agree that there needs to be something that would show that that this was a part of their lifestyle and not just a one-off thing on, I don't know, New Year's Eve or something of that nature.
Anything else? Okay, well, thank you very much. The matter has now been submitted. And we'll call the next case, item number 2, docket numbers 361717 and 361718, People v. Williams.
Good morning, Your Honors. Michael Frone on behalf of Mr. Williams. I think the elephant in the room for me is issue 4. I did a math error on that. I apologize. I think he did receive the correct number of jail credit. I don't know how I did that. So, if I could, I would withdraw issue 4. Fortunately, my wife's an accountant, so if she doesn't let me near the checkbook, otherwise, I don't know what a havoc I would have caused. But other than that, issue 3, 1 through 3, there's no brief on the other side, so I would stand on my brief unless the court has any questions.
Any questions?
I just have a question about the record. So did your client at some point talk about having 2 guns such that, or displaying both guns such that the gun in his backpack could be tied back to?
I don't have any memory of that at all. In fact, that's for issue 2, because the gun that was found when he was arrested, I think when they were arguing it, there was a period where they didn't know, and then the ballistics came in and it became clear that it was a separate gun from what was
But
used at the
I
shooting,
think
but he
that
may
the
have.
transcript indicated that he showed, quote, both of his guns, is what he
Okay.
said, and I think he did indicate that he had two guns with him on the night of the shooting. I think he showed both guns when he appeared at the house.
Fair enough.
That's what we're talking about. Is the second gun the one that was later recovered?
It could have been. It could have been.
Yeah.
That's a fair point. It could have been, but we don't know that. But yeah, I can't argue that it was not a gun that he had with him at the time of the shooting. I can't argue that at all. All I can say is it wasn't the gun used in the shooting.
And at trial, that was not at issue, whether the two guns were the same. And by the two guns, I mean the gun found in the backpack and the gun from the previous case. Was that discussed at trial?
Not to my memory. Not to my memory. Sometimes when I'll be honest, when I read the ballistics evidence and they're talking about they're using different exhibit numbers with different items, and I'm thinking of what was the gun used in the shooting. Could it have been mentioned? I can't stand here and say with certainty that it wasn't mentioned at trial. But I have no memory of that ever being an issue. Cases were joined. I will of trial counsel, arguing that the gun used in the shooting wasn't the gun found on him. I can't argue that one way or the other, that I don't have a clear memory on whether it was would have been ever clear to the jury that the second gun could have been the gun that was found on him when he was arrested, or that an argument was made that it wasn't. I don't have any memory. It could have been. I don't think it was a prominent part of the trial, but I can't. I apologize. I can't go. I don't want to state with. I know something with certainty when I don't. So I don't recall that being. I don't recall the prosecutor ever arguing that it could have been the other gun that was found on him. I don't have any memory of that. It wasn't a prominent part of the trial, but it could have been. At the end of the day, there were two guns and one found on him, and I would concede that I don't recall any evidence that would indicate that the gun that was found on him at his arrest could not have been the gun that was in his backpack or was shown, earlier. So.
And let me ask you one more thing. He was arrested with the gun in his backpack pursuant to a warrant about the first shooting. Okay, and that's not enough, in your opinion, for joinder?
Well, I guess my argument would be that the evidence is devastating for Mr. Williams. Now, admittedly, the defense said sort of a narrow ground in which to argue. He did admit to police he fired the gun. His friend or his girlfriend's son who was in the car said he fired the gun. So it was a self-defense argument. No one disputes he fired the gun. Lost track of your question.
Okay, it was just about whether the fact that it's an arrest pursuant to a warrant for the first shooting is enough for that joinder.
Right. So the evidence comes in, and this trial counsel argued it made him appear to be a violent, I don't know the exact phrase that she used, it's in the brief, but a violent person walking around with guns, gun-toting criminal, I think was the phrase that she used. So he had a defense at trial, self-defense, because in addition to what I just said, I should also point out that he did tell the police he thought he saw a shiny object in the other car. Caleb, legitimate defense that he made. There was some basis for, in fact, they did receive a self-defense instruction. But once that evidence came in, and so I think that my answer to Your Honor's question would be no. I think it should be tied in a lot more closely than that. That maybe the gun found on him when he was arrested might be a gun that he didn't use in the shooting, but he might have had in his backpack. That's, the argument is that's very tenuous. It's a lot of speculation there. But when the evidence came in, whatever hope he had of prevailing in his defense was gone.
Which evidence came in that?
The evidence I apologize, it's called evidence. Actually, the other case, the charge, the accusation that he had a gun on him when or the evidence that he had a gun on him when he was arrested.
Why did that destroy his self-defense theory from the previous case?
Maybe I shouldn't say destroyed it, but it damaged it.
Undermined it?
Right,
Why is that?
Because he then becomes, in the eye of the jury, a gun-toting criminal. He's always got a gun on him.
He brandished two guns earlier at the home. We know that he did do the shooting. So we
Right.
know he has guns and wouldn't we, and we also, in other places allow, evidence of flight shows consciousness of guilt and the fact that he has a weapon on him may show concerns about retaliation. So I think that it could come in for other reasons anyways. And I think for the R&O, for the fleeing the police, they had a warrant. We'd probably get evidence about the crime that they have an arrest warrant out for him for that crime too. So it seems very much overlapping.
Well, okay, that's, I understand, but I guess back to Judge Korobkin's argument. He did argue that, he did argue that the reason he had the gun on him that night was because Mr., I don't want to get his Baum, the other party that was involved in this, Baumcroft, that he had told him he was out looking for him and that he had a gun. And so that was kind of part of the argument of the self-defense claim, was that was why Mr. Williams had apparently 2 guns on him that night. So then when we find out, all right, he's arrested, he's got a gun on him, that also would have gone to undermine his argument. I mean, that's the argument that was made at trial. I hear what Your Honor's saying, and I can read, I'm making the counter argument. I think
Let me,
let's.
oh, go ahead.
No, you-
The gun toting language, did the prosecutor ever use that?
No.
Okay, so
not
that's just a shorthand summary of like, this
Right.
is, I think, a logical inference that the jury would make.
Right, exactly.
Or not even inference, it's just factual. He seems to tote
I think,
guns.
I think that's a phrase trial counsel used when she was arguing for there not to be a joinder.
Got it. Okay.
So let's say the cases are tried separately and you start the trial on the R&O and CCW trial. So for R&O, one of the elements is that it's a lawful arrest or something like that, right? And the defendant is fleeing or trying to resist a lawful arrest. So prosecutor has the burden of proving beyond a reasonable doubt that it's a lawful arrest. Does everything that happened at the house come in to prove that? Or does some of that get left out and all they have to show is there's an arrest warrant, but they're not allowed to tell the jury about why there's an arrest warrant? Does that make sense?
Yeah, it does.
Yeah, okay.
I think.
So what's I don't know the answer to that question.
I think the answer's the latter. I don't believe if the police have a lawful arrest warrant, I mean, that meets their element of a lawful arrest. I don't believe that allows in everything, no, that gave rise to the arrest warrant or that justified the arrest warrant.
Anything else?
Thank
Okay,
you.
thank you very
Mr.
much.
Brown.
Matter has now been submitted. We now call item number 3, dockets 362-727 and 366-230, People v. Burchich. Please correct me if I'm pronouncing anything wrong. I think anyone's I don't think anyone's remote.
Sounds like,
Okay.
which attorney? Okay. So Mr. Kershaw won't be appearing. Okay. Thank
Good
you.
morning, Your Honors. Jasmine Davis appearing on behalf of the people. May it please the court, this court should affirm Stephen Bursick's convictions and sentences in the Sheboygan Circuit Court docket numbers 2020-6006 FH and 2022-6325 FH. Some key points. Bursick's sentence of 58 months to 25 years for prisoner in a possession of a weapon is presumptively proportionate because it falls within the guidelines, and the burden is on Bursick to present this court with unusual circumstances that would show that the sentence is not proportionate. The only circumstances that Bursick points to is that he intended to use the razor blade for self-harm and not to harm others.
But that's
Yes.
gotta be at least somewhat mitigating, right?
I would say no, because the only elements of prisoner in possession of a weapon is that the defendant was in jail and that he knowingly possessed a weapon that could be used to injure another or
I think
attempt
that
to
gets at
escape.
sufficiency. So let's say we're with you on sufficiency.
Mhm.
The fact that someone, and I think there was testimony that he was in his cell alone. He had no cellmates. So he had no cellmates, used a razor to attempt suicide. And you believe that that's not mitigating.
I believe that's not mitigating because that's not how the statute is written. He's just as culpable of prisoner in possession of a weapon, whether he used the razor blade to injure another or whether he
But
did
how do you
not.
square that with Milborn considering the offense and the offender? That's distinct from, that's not tied directly to the statutory language. Put differently, this is considering the circumstances of the offense, which
Mhm.
don't negate the sufficiency of the evidence to support the conviction, but instead ask us to look at all the circumstances of the offense, which include the fact that he was alone in his cell, disposed of a razor, and attempts to take his own life. That, plus, I look at Milborn itself,
Mhm.
and there's, better than I think a lot of people, Milborn was during a time where there was a different sentencing scheme in place, but I think it's still apt to think about it because Milborn was convicted of like robbery or something like that. And he had gone into the apartment of his ex, and he used to live there, and the court considered all those circumstances and said, hey, you're convicted under a statute where you could be convicted for breaking and entering and intending to kill someone and breaking and entering. So the court considered, hey, there's kind of like how you are. Hey, there's a statutory language, but it includes this kind of behavior. So to your point, it includes behavior where you might intend to use that razor to escape prison, or you might intend to use that razor against someone else, but it also includes this. And the fact that it includes this with this limited area of harm is mitigating. And that's how the court in Milborn looked at Mr. Milborn and said, hey, you could have been convicted under the same statute for really heinous stuff. And we're not saying what you did is great, but it's just not the most extreme. And so what do we do with that fact that under the statutory language, there's this breadth of behavior, some which I think is more egregious to a larger number of people than self-harm.
Yes, Your Honor. Well, I would just counter that. When you think about like the prisoner in possession of a weapon cases, oftentimes it doesn't get to the point where the prisoner hurts someone else with the weapon. It's the safety risk. It threatens the security of the whole prison or jail for an inmate to be in possession of a weapon because let's say, yes, he was in his cell alone, but let's say that another prisoner gotten a hold to that razor blade somehow. And then all of the people that had to respond and they're away from their posts, all of the people who had to respond to the incident, even though he was just attempting to harm himself, that takes away resources from other places in the jail. And so I think when you look at the statute, I think if the legislature had intended to more harshly penalize prisoners who possess weapons with the intent to injure another, it wouldn't be worded in the way that it's worded that could be used. It's just the mere fact that the prisoner has the weapon. That's the crime in this case. And
There's not a separate statute for prisoner possessing a weapon with intent to harm,
no,
right?
no,
Okay.
Your Honor.
So given that, wouldn't we, if there were a different case where a different prisoner did possess a weapon with the intent to harm someone, wouldn't we want that case to be the one that gets sentenced at the top of the guideline range, which would then leave room for a case like this one to be sentenced either at the bottom or somewhere lower than the top?
Well, then turning back to the Milborn consideration, the
exactly.
circumstances of the offender, I think the trial court really emphasized the fact that this is a fourth time habitual offender with over a dozen crimes on his criminal record, including violent crimes, including a lot of drunk driving crimes. The judge was looking at Mr. Bursick as an offender when he sentenced him to the top of the guidelines. And a lot of that was his criminal history. So yeah, I would just argue the sentence of 58 months to 25 years, the burden, he has not met the burden of rebutting the presumption that the sentence is proportionate. I can't say that to say, oh, because he only intended self-harm, that's an unusual circumstance when that's just not an element of the offense in this
And for the
case.
criminal history, did the PRV calculations not account for the criminal history?
Well, yes, but I'm sorry, Your Honor. I would just say yes, but I still think that when you're dealing with someone with the type of criminal record that Mr. Bursick has, it's fair to sentence him at the top of the guidelines. And then that goes right into his other sentence for OWI third, which is 25 years to 50 years, which is far exceeding the guidelines recommendation. But focusing on his criminal history, he's a career criminal. His record spans back to 1992 when he was a juvenile. He had no less than 10 drunk driving or intoxication related offenses on his record at the time he committed this OWI third. And that's not including the 9 sentencing offenses. And one of the things that I think is interesting about the facts is that he was shown leniency on that very same day. When the officer saw the open container of beer in his car, he could have wrote him a citation for open intoxication, but instead he said, okay, I'm not going to write you up, but have someone drive you home. And Bursick said, I'll have my brother take me home. And then when the officer looked around, Bursick was gone. He drove drunkenly to the Green Docks. And then when you look at his record, he's never received like a hefty sentence like this before, but basically it's all to say that leniency does not work with Mr. Bursick. As shown by the very circumstances of this case. And so at this point, it is fair for him to receive a 25 to 50-year sentence. It is statutorily authorized because he's a 4th-time habitual offender. The court could have sentenced him to life or any lesser term. And the trial court made a valid point when it pointed out that he's really no different than the violent offenders that stand before the court. Just based on his record, he's just as dangerous to society because of his drunken driving as a more violent offender would be. So that sentence is reasonable and proportionate.
Does he, so setting aside the explanation,
Yeah.
does the trial court acknowledge or explain the extent of the departure? I couldn't identify where that happened on the record.
So I don't think the trial court specifically says, like, we're exceeding the guidelines by this much, and this is why this is more proportionate than that. I think the trial court more so uses the reasoning that I just stated, and that's the fact that based on his record, he's just as dangerous as a violent offender. So, you know, like a 4th-time habitual person who has maybe killed people or something like that, they would get life or a lesser term. And so I think that's how the trial court justified it. I don't think that they broke it all the way down into like, okay, we're exceeding the guidelines by this many months and this is why versus this many months.
I read Smith to require that latter breaking down. Do you think that's wrong?
I don't think you're wrong, Your Honor. And if the court would agree, then if there's going to be a remand, I would just limit it to remand for further articulation as to why the extent of the departure is, you know, more reasonable than a lesser sentence would have been. That the people would concede to that if that is necessary and required.
Thank you.
Yes. Is there any other particular issue the court would like to focus on, or?
Any questions?
I mean, I guess I'm curious, do you have any other examples of someone who received a 25-year minimum sentence when there was no one physically hurt in a drunk driving situation?
I don't, but I think it shouldn't take until someone gets hurt to sentence Bursick to a sentence like this, just because of the fact that he does have 10 prior drunk driving convictions. And then people were almost hurt in this case. I mean, there were the 3 kids at the Green Docks. He crashed his car into a residential neighborhood. And so I think it's fair to say, like, it shouldn't take until someone gets hurt to impose a 25-year sentence, just because of he's done this over and over and over again. And he drove quite a distance from the Walmart to the Green Docks. Anything could have happened in that time frame. So I think it's fair to punish him as if someone was hurt, because he did swerve his car at the minors. It was so close to someone actually having been hurt, and then coupled with his criminal history. That's fair, Your Honor.
Thank you very much.
Thank you.
The matter has now been submitted. We'll move to item number 4, docket number 371756. Carnegie Woods Property Owners Association v. Chaka, is that correct? Chaika, sorry. And I know we have a cross appeal here, so the logistics are a little bit more complicated than normal, but maybe if we could try to get everything initially and then rebuttal, and then if necessary, allow that again, but ideally not, so
Yeah, if it's all right with the panel, I'd just like to proceed on both sets of arguments this morning.
that'd be great.
All right.
Thank
Thank you,
you.
Your Honors. Good morning. My name is Stephen McKenney. I represent the appellant and cross appellee in this action, Bradley Chaika. There are just 3 issues I want to highlight for the court this morning, 2 of which go to my client's appeal and 1 of which goes to the cross appeal. First, I want to focus on my client's appeal and the issue regarding prescriptive easement. The trial court, and I want to kind of back up and set the scene here for the court, because I know it's sometimes difficult in brief writing to describe what's going on with property lines. Carnegie Trail is a dirt roadway, and it goes and it ends at its kind of farthest southwest point at my client's property. My client owns 2 pieces of property. One's in the subdivision, one's outside. At the end of the road, at the end of the Carnegie Trail, the improved portion of the road, everything to the west of that, to the west of the roadway itself, is my client's property. My client owns all of it. Anybody who is going from Carnegie Trail onto that old logging trail or onto the property anywhere is going onto my client's property. And so my client's really the only person with a lawful right to do that, he and his guests. I think that's important, and the reason I raise it is because the trial court said, in denying my client's request for prescriptive easement to use that roadway in that manner, that my client had been permissively using the roadway in that manner for a number of years. And I think the problem with that is the association, number one, there was no evidence the association gave them any permission to use the roadway in that manner. Number 2, the association isn't the one who could give the permission to use the roadway in that manner.
When you say in that manner, I just want to put a fine point on it. You're talking about him coming in from US 2
Yep.
onto Carnegie Trail in a vehicle that's not for recreational purposes. Let's say,
Yeah.
we're not talking about a 4-wheeler, driving directly onto lot 0
Yes. Or
Carnegie Trail.
from Carnegie Trail, or in some cases, he would walk directly from Carnegie. He would park his car on Carnegie Trail, because there's a little turnaround cul-de-sac there, and walk directly onto his property from Carnegie Trail. So there's both purposes. He testified to both purposes at trial. And where I think the trial court got it wrong was this notion that this was permissive use. It really wasn't. There wasn't any evidence of that. And really, the association couldn't give permission for the use. So I think the trial court got that wrong. I also think he got it wrong for the open and notorious reasons that we listed in our brief as well. Second issue I want to talk about this morning regarding my client's appeal.
If you're moving
Yes.
on, I wanted to
Yes,
go back to
yes.
that question. So you said that he would sometimes walk across from Carnegie Trail onto property 2,
Yes.
property 1. No, what are we, property
It's
0.
It's lot 0, yeah,
Lot 0,
lot 0,
thank
yeah.
you, lot 0. I mean, if he does that over and over again, walking, does that, and he does it for 15 years, does that create a prescriptive easement for him to drive a large truck?
No,
Okay.
I agree. I don't think it does, but I
Okay.
think that the evidence in the record was that he did both. I think that was his testimony and it was unrebutted.
But how does that meet the continuity standard? Even understanding the nature of the properties and things like that.
Right. I think that he did it. I mean, he both walked and used his car to access that lot 0 continuously for 15 years. I think he testified that he went up there,
But not
sometimes 2 to 3.
continuously. He testified that he also went on to lot 1 and would go lot 1 to lot 0.
Yeah.
So that's not continuous then.
I think his testimony was that he did both over the course of the years.
And how does that amount to continuity?
I think if you are using Carnegie Trail to access Lot 0 directly on a number of occasions per year for more than 15 years, that's continuous use, given the nature of the use. I mean, again, this is unimproved property. There's no house on it. He's not going up there to stay for a week at a time. He's going up there for day use only. I think his testimony was he never stayed the night up there. But again, over the course of 15 years, he's using it in the same manner. And one of the reasons we know this is because that 2-track, you can see the 2-track. You can see it in all the satellite imagery. There's an expert witness who testified you can see the 2-track. Somebody's driving a car over there for a continuous period of time, and that lines up with his testimony that that's what he did.
And is that what makes it open and notorious? Is that?
Well, I think that makes it open and notorious because you can see the physical, 2-track that goes in there. But there are other reasons that it's open and notorious use as well. Number one, he filed an easement purporting to grant himself rights and his neighbors to the west rights to directly access Carnegie Trail from there. That's a public record. Number two, there were issues at a meeting of the association in the late 1990s where he raised this issue and said, yeah, I'm going to buy lot 0 and I'm probably going to be driving over Carnegie Trail to get there. In the early 2000s, we had evidence that the association hired an attorney to evaluate whether or not he could do this. So I think all of those facts prove that his use of Carnegie Trail to directly access lot 0 was open and notorious. And if there are no further questions at this time, at least on the prescriptive easement claim, I would like to move to the breach of fiduciary duty claim just very briefly. The trial court's rationale for denying that breach of fiduciary duty claim sort of turned on this notion that, again, the core of the claim was my client's being treated differently than everybody else. And the trial court says, well, yes, but your client also did something that violated the bylaws, so I don't think he can maintain the breach of fiduciary duty claim. Couple of problems with that. Number one, I don't think there's any law that supports it. And I don't think that's the way we want the law of fiduciary duty to be applied. You should be able, if you're being singled out by your homeowners association, treated differently than all the other homeowners, you ought to be able to bring a claim and not have to prove that you're beyond repute or you haven't violated some minor bylaw. Secondly, the issue only came up at trial. This was never an affirmative defense that was pleaded. It only came up for the first time at trial. It was never the subject of any pretrial discovery or anything like that. This notion that, he was violating the bylaws by cutting down trees on his property only comes up at trial. And then the justification is made, well, this is actually a defense to the breach of fiduciary duty claim. And I don't think that's proper from a procedural standpoint. If there aren't any questions on that, I'll just turn briefly to the one issue on the cross appeal.
Can I just?
Yes.
There are no other lot 0s in this subdivision, right?
Yeah, there are no other situations like this. It's a unique.
So it's kind of a unique situation.
Yes, but as the evidence in the case showed, there were any number of people who traversed west. They essentially were trespassing over my client's property, but there are any number of people who use Carnegie Trail to go on hikes back through the woods.
Recreationally, right?
Yes, recreationally. And again, the other way the bylaws or the association acted out against my client was this notion that, oh, you can't have any commercial deliveries, to your lot and that wasn't the way they treated everybody else. Briefly on the cross appeal, the one issue I want to highlight there was an issue that came up in the reply brief. In the reply brief, the association raised the theory that it wasn't just the proprietor certificate that granted my client rights to use Carnegie Trail. They say, well, it's also in the deed restrictions. I went back through the deed restrictions again last night. I don't think it's anywhere in there. I don't think the deed restrictions say anything about who can use Carnegie Trail or what they can use it for. So that was just one issue I wanted to raise. It did come up in the reply. I don't think there's any support for it. If there are any questions on the cross appeal for me, I'm happy to answer those. All right. With that, I would like to reserve any time for rebuttal. Thank you.
Mark, plenty of time. Thank you.
Morning, Your Honors. Hob Engelson, Harry Engelson, on behalf of Carnegie Woods Property Association. The court asked in the front row there, with the exception of the young man in the suit, are some of the members of the association, which I believe, in fact, I know, is comprised of 49 lot owners, and then east of the 49 lot owners is another 12 property owners who also have the easement right under the deed restrictions for access to and from US 2. I guess it's interesting that Mr. McKinney and myself have the three same items as the hot points, so to speak, to touch upon, and touch upon only because you have indicated, and we understand, that a lot of work goes into the court's activities and understanding these cases for decision. So I too have limited comments. I want to emphasize, and maybe it is unnecessary, but I want to emphasize that we can't forego the idea that there's 49 lot owners in Carnegie Woods Property Association. Mr. Chaika, Mr. McKinney's client, had the furthest lot west at the dead end of Carnegie Trail. The name Lot Zero got applied to this piece of property outside of the association as part of the litigation process, so everybody knew what we were talking about. So Lot Zero is nothing more than the litigation figment that we all use, so everybody knows what we're talking about. I mentioned only Shaderwald v. Brule for the proposition that what Mr. Chaika has sought to do is extend the easement outside of the association. It's not permitted. It's not permitted. Unless that law is wrong, and I haven't seen anything to the contrary, it's not permitted.
Is your understanding that I'm sorry, can you say his name one more time?
Chaika.
Mr. Chaika is still using Carnegie Trail to directly access Lot Zero, or has that ceased entirely?
Well, comments today would suggest both, I think, but to answer,
Well, comments today would suggest that at trial, there was testimony that he used to drive on it. I don't know that there's anything yet said today about present day. My understanding was that present day, there's signs up, the gate's locked, and now we're dealing with going on to Lot Zero, or I'm sorry, going on to Lot 1 to Lot 0.
Correct. You understand, of course, it sounds like to me that the trial court ordered, and I'm answering your question, or I'm trying to, the trial court ordered, found and therefore ordered that Mr. Chaika had no right to use Carnegie Trail to directly access Lot 0, which is, as we all know by looking at the aerials, et cetera, it's the end of the road, there's a cul-de-sac, and there's a gate there. Just beyond the gate is Lot 0 outside of the association. Where the court, and this is kind of interesting to me, that where the court, in our view, diverged from enforcing the rights of the 49 lot owners, that Carnegie Trail was for the lot owners, for single family development, ingress to and from your lots, You had to go to the architectural committee if you're gonna develop your property, those kinds of things. Those were all the limitations on your easement, how you could use it. The trial court,
Sorry, those are the limitations on your property.
there are the limitations in the
Because no one's
forming
building a single
documents.
family home on Carnegie Trail,
I'm
right?
sorry?
No one's building a single family home on top of Carnegie.
No,
Trail.
no,
Okay.
they adjoin. Carnegie Trail is the roadway, the easement granted to each property owner who buys a lot. And therefore they, quote unquote, sign on to their obligations.
So my understanding of Mr.
Cheka.
Cheka's behavior is that when he is acting as a lot one owner, i.e. when he takes Carnegie Trail to access lot one, he is acting in accordance with the proprietor's certificate. And thus the trial court took no issue with that. When he was taking Carnegie Trail and going directly onto lot 0, the trial court stopped that because
True.
he was acting as a lot 0 owner and not as a lot 1 owner, not in compliance with the proprietor certificate.
Right. I mean, the court didn't articulate it quite like that, but that is the net effect is you can't use this road to go beyond our association. It's a private road. In an attempt to I guess, bring this to a close, so to speak, where we really have, exception with the trial court is it went on to say, well, if you go to lot 1, you're lot 1 within the association and it's okay to go over onto lot 0. And we disagree with that. That's why we filed the cross appeal. I mean, we raised other issues, but that was the focal point of it.
I understand conceptually why you disagree with it, but what I don't see is anything in the plain language of the proprietor certificate or the deeds to prohibit that, 1. And 2 is I don't see any evidence of burden on the road that would cause the court to believe that the road is being unjustly burdened or that the easement for the 49 other property owners is being compromised in some meaningful way.
To the first point, without searching through my brief, I believe that the language limits and the deeds limit use of the road because it says for the lot owners of the association, it doesn't say it's open to the public. It doesn't say it's not a public road. It's not a drive.
When someone drives down Carnegie Lane, when the owner of lot 1 takes Carnegie Trail to lot 1, that seems to, whatever they do after they're on lot 1, they have used Carnegie Trail in compliance with the language of the proprietor's certificate.
At that point in time, yes.
Okay.
To then use that same access and then go directly through the gate or through lot 1 onto the adjoining property outside the association is where we believe the court failed to follow the applicable law.
The law being what?
The law being that you don't get to unilaterally extend an easement right that's been granted to you of your own making, unable to do it. The Shadelwald case, the court will remember, was an access or an easement right given to the defendant who at some point in time after having it acquired another lot and then selected to or chose to continue through the lot which they got in the easement for into the next lot. That brought rise to the lawsuit. The court said you are unable to do that.
Right, but the Shadowwald case had an easement with plain language that was tied to the land. This proprietor certificate is tied to the property owners. So when the lot 1 owner drives down Carnegie Trail and goes onto lot 1, they're seemingly acting in accordance with the plain language, not unlike, that was the original problem in Shadowwald. You have an easement tied to a piece of property and you've extended it to a separate piece of property. But this easement is tied to the property owners, not the property. It says for the benefit of the lot owners. And so if you're taking Carnegie Trail directly to lot 1, you're acting as a property owner. What you do after that, I don't see how the easement language limits that.
Respectfully, I disagree, naturally. because you wouldn't be able to get to lot 0 but for having Carnegie Trail, which is the easement right given to you for the use and benefit of getting to lot 1. To extend it is a unilateral extension of its usage, however it gets used by that lot owner, which we believe the precedent doesn't endorse.
I mean, what I hear you saying is that we should interpret the words lot owners in the proprietor's certificate as implicitly being limited to the use of the lot that they own.
Correct.
Okay.
Correct.
I mean, it doesn't literally say that, but I understand that's
Well, if
the
we're looking,
interpretation you're advocating. here.
yes.
Yeah.
You asked me another question, Madam Justice, and that was about whether or not there was some impact. I believe you asked me an impact on the roadway, or I guess in effect, therefore, the property owners.
Yeah,
And
let me
my
jump in
answer,
really
I-
quick just
I
to
think it-
clarify. So
s-
there, so I know that there are trucks driving up and down. We got a motion before trial about that.
Right.
But my question was there evidence presented at trial of a burden on the road being caused by going down Carnegie Trail to lot 1 to lot 0? So that's my question. I know the present day stuff because I've seen the pictures and things, but my question is at trial, was there proof?
Well, there was limited discussion of that, and in our, speaking on behalf of my clients and myself and co-counsel, and our analysis was, to the extent that we had allegations of trespass by utilizing Carnegie Trail to go beyond the association to the west, lot 0, constituted an overburdening of the roadway, and we made a claim for damages. Our assessment of it was you couldn't calculate it, whether or not a logging truck or whether or not a construction truck or a cement truck or whatever came to lot 1 or 5 or 15 or, ultimately somewhere throughout, so that we didn't pursue that as a damage claim because you couldn't calculate it. You couldn't get there. Maybe I'm overreading your question, but I believe that the issue of whether or not this situation is legally enforceable, that is accessing property beyond the association by using the road Carnegie Trail in this instance, that there doesn't have to be some overburden kind of proofs, however great or minimal, rather that it's the proposition itself that it's not permitted. Well, I'll go on to the others if briefly. The second one raised by the appellant, by Mr. McKinney, was I think he raised the fiduciary duty one. I'll simply say we briefed that rather thoroughly, and I'm very comfortable in probably being the advocate for Carnegie Woods, but I'm comfortable that the action taken by Carnegie Woods Property Owners Association to bring litigation was triggered by the events in 2021 when Sean Clark, the logger, the man, he wore several hats, came in, cleared, then did site work, put a road across lot 1 and into lot 2 or lot 0. That was what gave rise to the disharmony between the association and Mr. Chaika that ultimately led to the litigation. And the litigation is provided for within the bylaws, and the section we've pointed out to the court was the architectural committee. You have an obligation to go to them if you're going to do any clearing, you're going to do any development, you're going to build a house, et cetera, none of which occurred, but the combination of them clearing or partially clearing lot 0 and then going on to lot 1, clearing lot 1 and going on to lot 0 triggered the action of the association on behalf of its members.
Did
And
the-
so there
did
was no
the-
breach.
Did the original complaint include a claim about the cutting of the trees? Was that part of the?
It does, it's in there, yes.
What count, which claim in the complaint is that, does that violate, or does that trigger?
I believe, and again, I don't have it right in front of me, but I believe, I can't name the number, Your
No,
Honor.
yeah, sure.
But I think we raised it in the commentary either as trespass.
That's the trespass
I
claim.
believe so.
Okay. All right.
I know we raised it because that was the trigger point in what we were raising as to why the litigation was brought. We also had a request, obviously, for costs and fees as well.
So the trespass claim was not related to the crossing through the gate or anything like that. That the trespass claim is about the cutting of the trees.
Well, it related to both the behavior of Mr. Chaika by hiring somebody to use Carnegie Trail to then do what they did on his property, more importantly, accessing Lot 0 by using Carnegie Trail, then going through his property and commencing the activity on the other side. I need to be quickly, so as not to take up too much of your time, abundantly clear. Mr. Chaika's ownership of, I think it's 5 acres or something west of the association. As far as we're concerned, because it's none of our business, he can do anything he wants with it if he were to come at it out in a different direction than what he is doing. Finally, prescriptive easement briefly, and we briefed this extensively. And I don't know if it's hard to understand, you know, we've lived with this for several years. You've had it for however long. The difficulty in proving the case, and I don't want to ever call it easy in defending the case, is Carnegie Trail you've read is from US 2 to the end of the terminus of it at the end of the association is over 3 miles long. And as I said, we've got 51 lot owners and their families and all those kinds of things. So absent anything unusual occurring, Mr. Chaika's coming and going would be no different than anybody else's coming and going, walking down the road, four-wheeling down the road, you know, I don't know, the electrician comes or whatever. All those kinds of things would raise no eyebrows and wouldn't meet any of the criteria for you know, the elements under Marlette or the elements under any of the prescriptive easement cases specifically. And then the contention that's been said, I don't believe it's in the trial transcript that he ever said they drove onto Lot 0, but I'll leave that to you folks at this point. All of the witnesses that testified, and we listed all the witnesses who did testify and their testimony, people didn't know him, people didn't see him, and there was nothing untoward about his property or any evidence that his property led to an outside lot across into the west beyond the association. Contrary to what's been said, the aerial photos were obtained by our expert, a forester who testified, and his testimony, and I'm happy to be told that I'm wrong, I don't think I am wrong, but is that there was no evidence of a road from lot 1 to lot 0 until the summer of 2021, when the excavation occurred, the tree clearing occurred, and then the site preparation work occurred such that you could see it from aerial photos and otherwise. And so there was no support for the prescriptive easement claim for all those reasons and for all the years that Mr. Chaika owned the property. Any other questions?
Questions? No, thank you very
I
much.
think I've used my direct and my rebuttal. If I have an opportunity, I'll take it. I don't know if I'll get it. It's up to you folks. Thanks.
Yeah, I don't think we'll need it, but
May I just have 2 brief points for rebuttal?
yeah, absolutely.
Number one, Judge Young, you had asked about the kind of the present day circumstance. And I think the trial testimony was up until the time of trial, at least, my client was using the direct access and access over lot 1 to lot 0. But I want to make clear, since the judgment, which says he cannot use that direct access, he is not directly accessed lot 0 because of the judgment.
And, okay, so but you are arguing for a prescriptive easement that would allow you to do, you allow your
Yes.
client to do that, but in the interim, you're just going lot one to.
Yes, in the interim, we are because of the court's judgment. Second, I think, Judge Korobkin, you had asked the question about what was in the underlying complaint. I'm highly confident there was nothing about cutting trees in the underlying complaint, but would rest on the court record, which speaks for itself.
So, if lot 0 were to be sold to somebody else,
Yes.
would you acknowledge that if that person was not the owner of lot 1, that person would have to find some other way to access lot 0?
The way the case stands right now, yes. They would have to either, try and go that back logging route and try and find their way, but you're gonna have to go over other people's property to do it.
Maybe
But
they
without
could deal with was it the Moorers?
the Mowers, yes, there's an easement with the Mowers that even,
You know, there's a lot of controversy
Yeah.
around that, but in
but there are
terms of,
further,
you're acknowledging in terms of, that the only reason Mr. Chaika can go to lot 0 on Carnegie Trail right now is because he happens to also own lot 1.
yes, under the trial court's rulings, which is obviously why we're here asking that portion of it.
Right, so you're saying if we win on prescriptive easement and Mr. Chaika sells lot 0 to someone else, the successor owner of lot 0 can benefit from that prescriptive
Correct.
easement. Is that what you're saying?
Correct, and
Okay,
that's a lot of the motivation for us being here today, yes.
that's helpful. Thank you.
Yes, all right. Any other questions?
Questions? Thank you.
Thank you, Your
both.
Honors.
I think the briefing really explained everything too, so. The matter has now been submitted. I guess it's 11, but we can keep proceeding. Okay. We'll now call item number 5, docket numbers 367028 and 367029, Mattson v. Braun. Sure. Whenever you're ready.
This is another cross appeal situation.
Okay. So I guess we could try to handle this.
And there are two
I
appellants.
represent
Yeah, there are
Orr
two separate
Kerrigan, the
appellants.
intervening plaintiffs,
Right.
and we filed our appeal, I think, slightly after the other one, but either one of us can go. I don't,
Yeah, I mean, however you want to allot the time and. So in the middle of having cross appeal, like, yeah.
Thank you and good morning, Your Honors. My name is John Evashevsky. I'm appearing today on behalf of appellants Bernice Mattson and Edward Marsh. And I'm trying to avoid going through any history of the facts. I know that you've read the briefs thoroughly. I would like to ask if it's a bit hard to distinguish when it comes to the plat, exactly how Sunset Beach is laid out and how it's situated. The plat came in roughly, I believe, 6 pieces. So I don't know if you'd like any just brief explanation how everything's laid out. Otherwise, I'll just move right into some of the more pertinent issues.
We've stared at that platform
Okay.
for a long time.
Yeah. Now, as you know, there was an opinion back in November of 2020. This case has been going on for 6 years. And trial court's opinion from 2020 seemed to insinuate that this plat and its dedication is not private in nature. It referenced that there were fee interests subject to abandonment. And there were reversionary rights when, in fact, I think it's undisputable and maybe even admitted by all the appellees that are in this case that this plat is in fact private. That's further established by very clear case law. The roads, the alleys, all dedicated lands are dedicated solely to the exclusive use of the lot owners of Sunset Beach. Now, it's my understanding and my position on behalf of my clients, I should say, that the appellee's argument regarding easement in comparison to fee interest in the dedicated lands of the plat is irrelevant. Three of the cases that have been cited over and over by all parties involved are Morse v. Colletti, Little v. Hirschman, and 2000 Baum Family Trust. Now, all of those cases required an analysis into fee versus easement interest in a plat because of a private dedication. And the private dedication granted exclusive use only to the lot owners. And so more specifically, it required the court to dive into the property interest, only, limited to the lot owners. Here, we don't have a dispute between or amongst lot owners. We have Sunset Beach and we have Lake Haven Estates, which is not part of the plat. They're not entitled to any use of the road system by way of the dedication. And because the dedication is private in nature, we're just asking that use of any of the dedicated lands be limited solely to the Sunset Beach lot owners. Now,
and we have different parties arguing different things, but it seems to me that, well, you could just tell me if I'm wrong about this, but if there's a dispute over whether the defendants actually own parcel H.
there is, Your Honor.
But your clients didn't really dispute that in the amended complaint. And so that has to be resolved, obviously. But if in fact the defendants own parcel H, regardless of who owns the roads, why don't the defendants have an easement by necessity over those roads to get to parcel H? And then if that's the case, we don't have to worry about Morse or any of these other things about, is there a reversion? Like if the defendants have an easement by necessity, doesn't that kind of resolve that question? And I understand your position is also, well, they don't own parcel H, but if they do, it seems pretty clear based on the record that they have an easement by necessity.
And Your Honor, that's a very good point. I anticipated that would be asked. And that's why with the explanation of the private nature of the dedication, I think, again, it's undisputed that absent an easement by necessity, they'd have no right to use any portion of the dedicated lands. And the reason I'm bringing that up is that the appellants in the trial court established that, or recognized and admitted that the private dedication of Sunset Beach does encompass parcel H. That it does encompass parcel H. And if that's the case, the private nature of that dedication would rule out any use by other than lot owners of Sunset Beach.
That's not what you pled in your complaint. In your complaint, you pled that the defendants own parcel H and they're using the roads, which are private roads. And please, trial judge, enjoin the defendants from using our private roads to access parcel H.
Yeah, and Your Honor, admittedly, there has been a lot of development in the 6 years, and in the last 6 years. I do have 2 additional responses to the easement by necessity claim. And beyond what I just stated on the record, if you do turn, this is, I'm only bringing this up for visual aid, but Exhibit B of the brief filed on behalf of Ms. Mattson and Mr. Marsh. And it's page 2 of the plat, actually, excuse me, it's page 3 of the plat. You can see the road system, you can see Sunset Beach Drive, which traverses kind of along the shoreline, but there's a lot of space between the shoreline and Sunset Beach Drive that's not encompassed by the plat. Parcel H is part of that. At the time of severance, when this became a plat, Indian Lake Company, the common grantor or platter, retained title to this beachfront. It's still accessible by a private road without even traversing into the private roads of Sunset Beach. And you can see, I believe the word is Galler, that's a last name. And more specifically, south of lots 138, 139, and 140, there's a portion of Sunset Beach Drive that allowed continued access. Only after that did parcel H become severed. So it's
So are you're arguing that there's a dispute of fact over whether parcel H is truly landlocked?
Well, no, Your Honor. I'm arguing that parcel H, at the time that it became landlocked, the easement by necessity was not located or situated within the confines of the plat. There was access from a public road, again, south of lots 138, 139, and 140.
And so that undermines the easement by necessity claim?
I guess perhaps not.
I'm just trying to understand
Yeah,
the important, what you're getting at.
Perhaps not the claim itself, but the location of the easement and the necessary parties to name, as it wouldn't require traversing through or be authorized to traverse through the private plat dedications. And then one other point, Your Honor, just given the easement by necessity claim, the Sunset Beach subdivision was created in 1937. For some reason, there was about a 9-year gap before it was recorded in 1946. Parcel H was not recorded, or excuse me, really even created until a 1983 deed from the Cardiffs to William Bowman. So we had approximately 35 to 40 years of existence and record notice of these private plat dedications, putting the rest of the world on notice that these are private roads, and then parcel H is created. There was no ability to warrant access to parcel H in any way from Mr. Bowman. And just from a standpoint of record notice, we're just asking that the plat not be disturbed. And that's why with the use of the private roads, we're asking that it be prohibited, except for lot owners within the confines of the dedication. And then another, actually, Your Honor, I think I'll allow Mr. Engelson to bring up the dedication over parcel H. I think you've made it clear that I should probably refrain from that, having not pled it originally back in 2019. And I do feel it's necessary to bring up the November 2020 opinion from the trial court, and that was actually Judge Rahley's predecessor, Judge Carmody, who's now retired. But within that opinion, he found that the plaintiff's trespass claim, asking that the court prohibit use of the dedicated lands, should be dismissed because they had only non-exclusive easements throughout the entirety of the road network. That was never admitted. The lot owners of Sunset Beach, no single lot owner has an exclusive easement over the road network. It's a collective exclusive easement only for the lot owners. Beyond that, as established by Morse v. Colletti, plats that predate January 1st of 1968 give a fee interest in the roads here in this case. Specifically, Ms. Mattson and Mr. Marsh, they own lots 147 and 148. And because there are lots across the street from them, Ms. Mattson and Mr. Marsh actually own fee simple interest halfway across 2nd Street. And then from their lot 147, they actually own the entirety of Sunset Beach Drive within the confines of the north boundary and south boundary of 147. So there are fee interests here. And in addition to that, lot owners of a plat do have standing and the ability to bring a claim just given easement rights. And that's been established by Morse v. Colletti, Little v. Hirschman. That's been established by, or arguably by, the Trespass Liability Act, Land Division Act. So even independent of these fee interests in the dedicated lands, they would have standing just based on easement rights. So just to summarize, I think, again, I'm going to leave the argument as far as the dedication applying to parcel H to Mr. Engelson. And I think you've narrowed down the issue. It's if an easement by necessity can't exist, given these facts. And I don't know if there are any questions. Any questions?
For me.
Thank you.
Thank you.
Good morning again, Your Honors. Whoops, sorry. I'm smiling because the amount of timber that went into the briefs that we have prepared and submitted is daunting. And then I've gone over and over this case in preparation with my clients, who, as you have gathered from the record, I think, Mr. Orr, Chris Orr, and Kathy Kerrigan are husband and wife. Chris Orr is the grandson of the originators way back when, and his grandparents first took ownership of the deeds in question like 1939. I'm going to say all this in short version, okay? We believe because of the deeds given to our predecessors and ultimately to Mr. Orr and Mrs. Kerrigan, that they gave to them the same kind of rights that the developer gave to the other lot owners in Sunset Beach. Number
And
one.
where is that in the,
Pardon?
where is that in the Orr deed? Is that the language from the Orr deed that says you can use the horse paths and the beaches? And is that what you're referring to?
Yes,
Okay,
yes.
okay,
Okay.
thank you. That's helpful.
So with that premise, depending on how the court views what the other property owners got, if we got the same thing, and then we roll forward to the Bowman activities in the 1980s, when they created a deed, named it Lot H, sold 1/14 shares, the analysis is the original plat owner could not take back what they had given, nor could any successors, Bowman's being the last. And so the idea
Assuming they gave fee simple ownership as opposed to merely an easement. Is
Yes.
that right? Okay.
when you say they, I better correct. When you
Well,
say
Lake,
they,
Lake Indian and then everyone up to the Bowmans. Indian Lake, the Indian Lake Company
then Cardiff,
and then
right?
Carter, right?
Right.
When they convey to,
Bowman?
well, yeah, well, some of them conveyed to the Orrs,
Sure.
right? And some of them all, and then they also created the plat. And the plat has a private dedication. And it seems to me that the main question in both of those situations is when they say, you know, you can use the roads and the horse paths and the beach and the playground, is that fee simple or is that easement?
I think that's an easement within the deed of ownership that you got with your lot that you bought.
So,
And
go ahead.
I didn't mean to interrupt.
No, please go ahead.
My comment and our position is that because of that, Indian Lake Company itself and anybody after it couldn't turn around and take away some of the easement benefits or dedications or restrictions they gave either in the plat or in the deeds. Mr. Bowman's, and therefore Mr. Bowman's creation of 1/14 interest and creation of Lot H and then dividing it in 14s and selling it to people across the street as part of the marketing of Lake Haven Estates is invalid.
But wasn't the creation of wasn't the conveyance of the parcel H ownership to defendants, wasn't that subject to the easement that all the Sunset Beach subdivision owners had and that the Orrs had?
My opinion,
I'm just trying to piece together, this is
No,
a
I'm with
puzzle,
you.
and I'm trying to piece together the puzzle.
I'm with you. Our position is that they could not take what was an easement right benefiting all those people in Sunset Beach and below, and converting it into a lot, into a deeded parcel, they then divided up and sold to other people. Couldn't do it. And and that's why we had the alternative claim here, to be clear, if that turns out, because the court so rules that from its inception, my clients never got an easement right, and what is now called parcel H was not reserved as an easement for the benefit of anybody in Sunset Beach subdivision, then our clients, by virtue of their behavior as testified to and briefed in all the deposition testimony, took ownership by adverse possession, because from 39 until, at a minimum, I'm pointing over here, the appellees have one person, McDonough, who signed an affidavit or something, where they take the position in 1970 and forward, he or his family started actively using the property. Even at that point in time, from 39 to 70, you're 30 some years. And if the evidence that we have presented, and it's uncontroverted, because I don't know, my people are so old and nobody else was around apparently, that if it's accepted as evidence that sustained the proposition of acquiring adverse possession, they did. And if they did, then the outcome should have been the court should not have granted summary disposition against us. And the end result, it will be that the property belongs to my clients by virtue of that occurrence over those decades. I have one more, and it's somewhat my business. I'm troubled by that whole concept, not because I oppose it, because I believe in the first instance that Mr. Bowman, like his predecessors, had no right to create a deed and sell off what was dedicated to people, number one. But if in fact that wasn't reserved or preserved, then how about all the streets, beach and waterfront? Because if it falls all under the same umbrella, what do we have? I don't know. Practically speaking, you're not going to start selling off and closing off the streets because nobody would get anywhere. But they all fall, it seems to me, in that same basket legally. So that's all I have. If you have any questions.
You guys have left a little time for rebuttal, so thank you very much.
Good morning, Your Honors, and may it please the court. I'm Ben Parmet on behalf of the appellees. I want to highlight two lines of case law here, excuse me, because I think they draw a really nice logical line through every issue that comes up here. The first line is Little v. Hirschman and Morse v. Khalidi. Little v. Hirschman says plat dedications pre-1968 are easements. They're irrevocable easements. They are not fee interests. Now that's followed up with Morse by Khalidi that expands on Hirschman. It says, okay, you're correct in Hirschman that we have easements, but it could be more depending on the circumstances, depending on the language. So then we get to the second line of case law, Uzenvacht and Smith v. Edwards. It says we presume an easement is non-exclusive unless there's language that says otherwise. And in Smith v. Edwards, they say calling a street private does not necessarily create exclusivity. You can still have a private dedication that is a non-exclusive easement. Now we look at the case here. I think counsel in another case said in property cases, it can be a bit hard to visualize where everything is Here at the extreme west, we have the water, then we move east. There is a beach right next to the water. That's where parcel H sits. Everybody admits this thing is completely landlocked. There's no other way to get there for any owners except over the road network, which is a little bit further east, farther east, where the appellants live and own property. There is a road network of 10 private roads there. And then we move a little bit farther east, we have a public road. And then east of that, we have where my clients own land. And they have been crossing over this Sunset Beach subdivision on the roads there for many years. Now, when we look at how this parcel H came into being and how they've traditionally accessed it, they've passed over Sunset Beach, they access parcel H. Now, the initial argument, which I think Judge Karopkin pointed out from the plaintiffs here, was that there is an easement over parcel H. They did not own, the plaintiffs did not own parcel H. They held an easement over parcel H. And that's correct. They do hold an easement over parcel H. Now here we have a pre-1968 plat. It grants use over the roads in the Sunset Beach subdivision. And I believe the intervening plaintiffs in one of the first paragraphs of their initial complaint admit that this was designed for use by Sunset Beach owners to access the water. That is classic use, non-exclusive easement language for the plaintiffs.
Well, it's clearly classic easement language. I think if I'm understanding correctly, the dispute is whether it's exclusive use or non-exclusive use. Because
Completely
if it's
agree.
exclusive use, then that changes things.
Certainly, Your Honor, I completely agree. But I think the way if we look at the Uzenvach v. Miller case, we presume that the easement is non-exclusive. Now here, I don't see any language in that plat that would create an exclusive easement because there is no use of the word exclusive or solely for the use for such and such people. So we have to presume non-exclusive easements. Here, when we get into the issues themselves, we have, if we're looking at the easement by necessity issue, we have one owner of all of this property. And throughout the years, we have a small piece of this land that is landlocked. And traditionally, the only way to access it is by passing over someone else's land. That is classic easement by necessity language to access, or easement by necessity situation to access parcel H. So it's clear here that because the plaintiffs here only hold an easement, not the fee interest in parcel H, and the defendants, the appellees, can only access this land through Sunset Beach, we have a classic easement by necessity situation. Now, looking at the other issues that were brought up here, again, the case law is extremely helpful. Was the trial court correct in denying a request for injunction because of alleged trespass? They were correct in denying that because to create trespass, you need to have the exclusive right to use and hold the property. Here, there are non-exclusive easements. So there was no exclusive right. It was correct to deny the easement. Was the trial court correct in denying the claim for adverse possession over parcel H? They were correct in denying that. And the key point there is hostility. Now, the plaintiffs, were they using parcel H? We don't deny that. However, they were using it in line with the easement that was created in the plat. So there was no hostile use. There was only use in line with the easement. So they don't fall within adverse possession. The next issue.
And their easement comes from
Plat
where?
itself, Your Honor.
But I thought that oars are outside the plat.
I don't believe parcel H is outside the plat, Your Honor. Now, the trial court correct in denying reformation of the Pelley's deeds in the Lake Haven Estates. I think it was correct in doing that because they create an ownership interest in parcel H, an ownership interest that the appellants don't have. Issue 4, was the trial court correct in denying the appellant's request for quiet title? Of course they were, because they don't own the property itself. Were they correct in denying the request for negative reciprocal easement? Well, I think the most obvious response to that is they don't need a negative reciprocal easement over parcel H because they already hold an easement over parcel H. It doesn't make logical sense to grant them that. 6, was the trial court correct in granting an easement by necessity? We've already covered it. Yes, this is classic easement by necessity situation. This is an interesting issue. Was the trial court correct in denying the motion to join parties? I think they were. Now, really what this comes down to here is a permissive joinder or a compulsory joinder situation. And here it's a permissive joinder. The original plaintiffs sought for a compulsory joinder of basically 2 entire subdivisions here. But the reason we argued and the reason the court decided, this was Judge Carmody, the previous judge, decided that this was a permissive joinder situation is because these are non-exclusive easements. I think the way I put it at the final hearing on this matter was non-exclusive easements. You can stack these things on top of each other and they don't really interact. It doesn't create a problem. And that's why this is permissive joinder. These other owners don't necessarily need to be added. And the original plaintiffs had years to join these people and they didn't do it. Several of them, however, were added by the intervening plaintiffs. And I think it's important to point out that as it pertains to the defendants that came on later, that argument for joinder is effectively waived because they weren't part of this beforehand. So that's my argument, unless the court has any other questions.
Any questions? Well, thank you.
Thank you very much.
Good morning, Your Honors. Matthew Turchin appearing on behalf of appellee Ryan McDonough. Your Honors, I just want to highlight a few important waiver and preservation issues that pertain to Mr. McDonough specifically, and perhaps some of the other defendants as well. I concur with everything Mr. Parmet said as to the substance of this matter. And although this may seem like hyper-technical appellate hair splitting, I think this is important because it goes to what issues were argued in front of the trial court, what issues the parties had the ability to develop, and develop a record that the trial court could have ruled on and that this court could review. These preservation issues fall into 2 categories: issues that arose before Mr. McDonough was a party to this case, and also issues that arose after the trial court granted summary disposition in favor of the defendants. As to the issues raised before Mr. McDonough was added, plaintiffs are claiming that the trial court erred by dismissing their trespass claim and by denying their motion to require joinder of additional parties. Mr. Parmet just spoke to this a little bit, but as a preliminary matter, it's important to note that in the original complaint filed by plaintiffs Mattson and Marsh, McDonough was not a party at all, and they never amended their complaint to bring trespass claims against him. Even setting that aside, the trespass issue was decided on October 19th, 2020, and the joinder issue was decided on May 20th, 2021. Mr. McDonough was not brought into this case and did not appear until June 3rd of 2021. Those issues were never raised again after he became a party to the case, so those issues are waived. He never had the ability to contest those or to litigate them at the trial court level. As to the issues that were raised after summary disposition was granted, there are 2 of them. The first is the intervening plaintiff's contention that there's a chain of title issue, that somehow the defendants did not acquire title to parcel H. If you look at the trial court filings regarding the parties' cross motions for summary disposition, this simply wasn't an issue at all. What happened was that the plaintiffs Mattson and Marsh, their counsel obtained a title search. You can see that in our appendix. There's a letter attached to it. It basically says this is the title history for parcel H. And I think everybody essentially took that for gospel. The only 2 issues that were really addressed in the summary disposition briefing were how do we interpret this plat dedication as it pertains to the ownership of parcel H? And did the plaintiffs acquire title to parcel H via adverse possession? Intervening defendants or the intervening plaintiffs did not raise any issues regarding the chain of title or like the math regarding the boundaries not adding up until their summary disposition was granted against them. And they raised the title issues for the first time in their brief on appeal. So we contend that those issues were waived. They were not preserved for review. The second unpreserved issue that they raise is their contention that there's some kind of zoning issue here that prevents parcel H from existing. This issue was first raised in their motion for reconsideration at the trial court level. We've cited case law in our brief stating that that's not preserved for appellate review. And even if you look beyond that, the intervening plaintiffs don't tell us what zoning ordinance was violated here. And even if a zoning ordinance was violated, how that would translate into them somehow not having title over parcel H. So we contend that that issue was waived as well and shouldn't be considered. As to the issues that were in front of the trial court, we believe that the trial court got it right. So unless your honors have any questions, I would ask that you affirm the trial court's decision.
Any questions? Any questions?
Thank you.
Thank you. Now there.
I'm mostly going to address Mr. Parmet. Now, referring to Morse v. Collitti, it's not just an easement. The case has established that not only are there easement rights and fee interests, but it specifically references the private nature of the dedication, and it makes a reference that even a dedication, and this is the language taken straight from the appellant's brief, the use to the present and future lot owners, language as simple as that, created private dedication rights and prohibited non-lot owners from using those dedicated lands. So it's not just an easement. And addressing the easement by necessity too, not getting into the points that I addressed earlier, but just more of a response to Mr. Parmet. The trial court's decision, even if worst case scenario for the appellants, if an easement by necessity is considered to legally exist, which we contest that, the trial court gave Lake Haven Estates, which there could be up to 14 owners, 14 lots, use of the road network in its entirety. And the way that the road network is laid out, you have 1st through 9th streets where predominantly most of the lots and homes are situated amongst those streets. And there's a road beginning at County Road 441 south of that, as I named earlier, Sunset Beach Drive, that gives more reasonable access. And the requirement of an easement by necessity that the trial court did not address is it needs to have as little burden as possible on the serving estate. And there's even case law cited within the appellant's brief. You've probably read that serving estate owner, or here it's the entire plat, actually has authorization to choose where that route should be located. None of that was done. So again, just as a last resort argument, if an easement by necessity is considered to exist. And then just briefly addressing Mr. Turchin's argument about trespass. The only parties that Ms. Mattson and Mr. Marsh ever witnessed using the road network, which originated back in 2018 or 19, were Appellees Braun and the LaBars. There were 3 of the Lake Haven Estates lot owners using the road system. That's all they ever witnessed. They were named as defendants immediately and subject to the trespass claim.
And then I think the plaintiffs were the only residents who were sort of concerned or upset about this situation.
Yeah, and Your Honor, they own lots 147 and 148, which
They're the most directly.
exactly.
affected,
Yeah, so and that's how with all of these alleys, if you looked at the plat, including parcel H, they're directly across, which is pretty common in plats that have waterfront, but they're directly across from 1st through 9th streets, and that's to give non-waterfront lot owners access to the lake. And that's where parcel H is 2nd Street's alley, as we argue. And accordingly, beginning in 2018 or 19, the appellant Mattson and appellant Marsh's Second Street property was subject to travel. So that's where the trespass claim originated. I don't even know if they could have really named the other Lake Haven Estates lot owners, having not seen them, without authorization using any of the road network. And then one other issue, just hypothetically, it's the very existence of public and private dedications. We've established that this is a private dedication, and it should not be treated as if it's public and subject to use of any outsiders. And that's the protection of a plat. There are downsides to owning in a plat. There are restrictions, there are fees, but this is one of the protections. You have not only protection against outsiders using the road network, but you have protection in numbers, which is why we requested that the court compel the appellees to add all necessary lot owners. And that only became necessary upon filing their countercomplaint. Those claims in the nature challenged the property interests of all lot owners. Thank you. Do you have any further questions, Your Honors?
No further questions.
Thank you.
I'm all set, thank you.
Well, thank you all. The matter has now been submitted. We'll call our final case for the day. Item number 6, docket 367091, Nairn v. Department of Environment, Great Lakes and Energy. Believe only one side is endorsed.
Bear with me, I'm vertically challenged here. May it please the court, Assistant Attorney General Elizabeth Morisseau appearing on behalf of Respondent Appellant, Michigan Department of Environment, Great Lakes and Energy. First of all, I want to thank the court for granting our motion for consideration so that you can hear this important interlocutory appeal. I had a bunch of written remarks and I threw them away while I was sitting away this morning. So what I just want to make clear to you today is that this case is just a standard statutory interpretation case. The circuit court, when it was sitting as an appellate review of an administrative body that did a contested case hearing, and then a reviewing administrative body that reviewed that contested case hearing, all the circuit court did was overturned 2 conclusions of law. And it did so on the basis of words that are not found anywhere in the applicable statute. So this court should use a de novo review to determine whether the circuit court properly overturned those conclusions of law. It bears emphasizing the circuit court did not upend any of the factual findings before it. It was specifically just those 2 conclusions of law. And so the department is here to ask this error correcting court to correct the 2 statutory interpretation errors that the circuit court engaged in when it overturned those 2 conclusions of law. If there are there specific questions? Otherwise, I'm happy to talk through any part of this argument.
Questions? Start? Yeah.
Do we
please.
have, if we send it back, does that go back for more? Does that go back to the circuit court or back to the ALJ?
If this court,
If we agree with you that there were errors of law by the circuit court, what happens then?
then the underlying administrative decision stands, which was a denial of the permit. And if the permit applicant wishes to appeal this court's decision, then it could seek leave to
Yeah,
do so.
right.
But
But on the
it-
remand, you're
it
saying
would
we
just go back. And part of the problem is what the circuit court did. So the first thing it did, sort of relevant to this question of narrowing a project, it inserted a malfeasance requirement. It didn't look at any of the precedential administrative decisions that basically make very clear that an applicant is not entitled to describe a project in such a narrow way that it limits the department's review to one specific wetlands parcel. And so correcting the error that there's no intent requirement then would affirm the administrative decision below that the applicant had improperly narrowed what the project was. And he's then free to build his project on uplands nearby. And then the second issue, which relates to one of the other properties that the administrative law judge found as a feasible and prudent alternative. What the circuit court did there was the circuit court says, all right, if a related corporation owns this property, then you have to pierce the corporate veil before you can look at it. And that's not what the text of the law says. The text of the law says, irrespective of who owns the property, if the department rebuts the presumption that it's not available, then it can be considered as a feasible and prudent alternative.
I think it has to go back to the circuit court though, because they didn't answer all the questions before them, right? I mean, they did. So let's say we agree with you. Okay, they committed these errors, legal, factual, but there were still other questions that they kind of pushed to the side because they decided this on different grounds, right?
The entire permit denial was put before the circuit court to review, and those were the two conclusions of law that the circuit court decided to overturn.
Yeah, but I don't think it addressed whether the project will cause an unacceptable disruption to aquatic resources or whether the project was not in the public interest. That I think it'll have to look at on remand if we do reverse on those grounds, because they weren't answered the first time.
That's correct. I guess that it could be remanded to the circuit court, and essentially those two conclusions of law stand, and then it would be the other conclusions of law that would be what the circuit court would have to review. And I apologize, I do not have the circuit court briefing in front of me. And I cannot say off of my memory whether the appellant challenged additional conclusions of law. I believe that he did. Those two conclusions of law truly are determinative, because once the project is not artificially limited to this wetlands parcel, and once the other property is available for review, it makes looking at those other conclusions of law much easier to do. It's plain because there is a feasible and prudent alternative elsewhere. The presumption under the law is that if there's a feasible and prudent alternative, then you must do it. It's not in the public interest to impact those wetlands.
Okay. Any questions, anything else?
I could happily stand up here and talk about wetlands for the next hour, but I'm sure that's not what this court likes. So the department just respectfully requests that this court correct the circuit court's errors and find that the administrative law judge and the administrative reviewing body properly determined that, one, the project was too narrowly described, and two, that the department rebutted the presumption that the related property was not available for review as an alternative location.
Thank you very much.
Thank you.
Yeah, your briefing was excellent.
Thank you, Your Honor.
The matter has now been submitted, and I believe that concludes our call, so I think we can